Hi, good morning, everyone. This is Jason Weber from the AEC. Wanted to make Robert DeFrancesco available to everyone this morning. Obviously, a lot of things going on with the IEEPA ruling at the end of last week, and then the subsequent actions from the administration. So we thought it would be appropriate to get Robert have this webinar. We are going to keep everyone muted during the webinar, but we are monitoring the questions and also the chat boxes. So if you do have any questions after Robert's presentation here, please enter your questions into the appropriate box in the webinar system. So without further ado, don't need to really give Mr. DeFrancesco the typical introduction we give for webinar attendees, but Robert, please take it away.
All right, great. Thanks you, Jason. So I don't have any slides. We're just going to talk generally about how we got here and what's next. So as I'm sure everybody on the call is aware, obviously the Supreme Court ruling was last Friday. It involved the president's IEEPA tariffs. IEEPA is the name of the statute that was used to impose the global tariffs, initially on China, Canada, Mexico, and then the rest of the world. The legal challenge itself involved the China, Canada, Mexico tariffs, but the Supreme Court decision addressed the use of IEEPA generally to apply tariffs, so it really does affect the overall global tariff structure that the president put in place. The important thing to remember is that tariff program does not affect any of the 301 programs, so the China 301s. It does not affect any of the 232s that are in place or any other tariff program. So it is limited only to the existing, or what they were using at the time, that IEEPA program. And as everyone remembers, within that IEEPA program, there were various exceptions, carve-outs. So there were certain products that weren't covered. Mexico and Canada there was a USMCA exemption that they put in place, that products coming from Canada or Mexico that were USMCA compliant were exempt from those IEEPA tariffs, and of other sorts of carve-outs. So the Supreme Court decision followed a series of similar reasoning as the lower courts. So the first item in the Supreme Court decision that was of note was, you might remember, there was an appeal at the Court of International Trade, which is a U.S. federal district court in Manhattan. It's the equivalent of a district court. The Court of International Trade handles all trade cases, all cases involving customs, tariffs, other sorts of tariff programs. And then there's a second appeal in the DC Circuit challenging the IEEPA tariffs as well. In a footnote, the Supreme Court decision was very clear and said the case in the DC Circuit has no jurisdiction because this is a case that involves the application of tariffs and the collecting of duties. The CIT is the appropriate court, and that is the court with jurisdiction. So they basically reversed the DC Circuit application of a preliminary injunction and its finding on the IEEPA tariffs. And so they focused only on the CIT findings and then subsequently the CAFC findings. So the CIT, in a 3-judge panel, found that the IEEPA tariffs were inappropriate, that the president didn't have the authority under the IEEPA statute to impose tariffs. The Federal Circuit ultimately upheld the CIT. So the 3-judge panel at the CIT was unanimous. The Federal Circuit decision was 6-4, and then the Supreme Court decision was 6-3. And there were parts of the Supreme Court decision where there were concurrences, lots of different parts of the opinion, some concurrences, and then obviously the dissent. But basically, if folks remember, the Court of International Trade found that the IEEPA statute, while it contemplates providing the president with the authority to regulate imports, regulating imports and taxing imports aren't necessarily the same thing. And they distinguished the prior statutory provision that existed prior to the IEEPA statute, which came into force in the 70s. The prior case, or the prior statutory provision, was in the Nixon administration, where the Federal Circuit actually upheld the use of tariffs in that context. So the Supreme Court decision followed very similar reasoning. They focused only on the degree to which the statute actually gives the president the authority to impose tariffs. It did not really discuss any other aspects of the program, and they followed very similar reasoning that was laid out at the CIT, where the majority said regulation of imports is not the same thing as taxing the imports, that Congress, and they applied the major question doctrine, which, for those Supreme Court scholars, in the most recent iteration of this court, the conservative wing of the court essentially discussed this idea of the major question doctrine, and they used it principally to overturn Chevron, which has existed since the 60s. And for administrative law geeks, which is what we practice, Chevron was a Supreme Court decision that talked about if a statutory construction is vague or not clear, that as long as whatever the agency's decision that's made to fill that gap in that regulatory structure, as long as it's reasonable, then the court will defer to the agency. And a lot of conservative scholars believe that this Chevron doctrine led to an administrative state that allows the EPA and other sorts of agencies that some of the conservatives don't like to fill those gaps more aggressively and push beyond what Congress had intended. So a few years ago, when the court overturned Chevron, they talked about this idea of this major question doctrine. And the major question doctrine, as they articulated, was, is this a fundamental principle that's set out in the Constitution? And if it's a major question, then we have to look at the degree to which Congress explicitly delegated authority to the administration to fill that gap. And here, the wing of the conservative justices, along with the three Democrats didn't join in the major question doctrine discussion, but they joined in the holding, which was that Congress, because the taxation authority is so fundamental and so fundamentally spelled out in the Constitution, that is a major question that has to be examined within the statute, and the degree to which that authority was conceded to the president. And again, they focused on this distinction between regulation and taxation. They kind of glossed over the fact that, well, you can regulate something through taxing something, but at bottom they said, regulation is different than taxation. We don't equate the two, and therefore the statute didn't give the president the authority to impose tariffs, which means that the China tariffs, the IEEPA tariffs in Canada and Mexico, and then all the other global tariffs were invalid and can't be imposed by the administration. So that happens Friday at about 10 o'clock in the morning. at 5 o'clock that evening, the president announces that they will be imposing tariffs under Section 122 of the Tariff Act of 1974, which is the balance of payments provision. So they signed an executive order on Friday night. They signed two executive orders, one repealing the IEEPA tariffs and then the other imposing tariffs under Section 122, which are global. What they did in the 122 decision was attempt to mimic the structure of the IEEPA tariffs. So just like the IEEPA tariffs had two different annexes that identified types of products that were exempted, those annexes exist in the 122 executive order. Just like the IEEPA program had exemptions for USMCA compliant goods, they mimicked that language in the 122 executive order. So they tried to keep as consistent as possible between the IEEPA program and the 122 program. The 122 program is time limited, so the tariffs can be in place for 150 days before the administration has to go to Congress to get that renewed or approved to stay in place. I'm sure people saw that the executive order imposed tariffs at a 10% level, and then shortly thereafter, the president tweeted that the tariffs would be going up to 15%. Currently, the tariff rate is 10%. The executive order was signed at 10%. The Federal Register notice is being published or was published implementing tariffs at 10%. Ambassador Greer this morning was, I think it was on Bloomberg, indicated that there would be another executive order moving the tariffs from 10% to 15%, but that hasn't come out yet. So ultimately, we'll get to 15%, but we're not there yet. And there's a possibility that for certain countries that struck deals with the administration, they may remain at 10, and the other countries will go to 15. But that's not clear. So that's where we are currently with the 122 to backfill. Also on Friday, as part of that announcement, the president asked USTR to initiate a series of 301 investigations to implement a more permanent tariff program after that 122 program runs out. So it's not clear yet whether we're talking about one 301 investigation, multiple 301 investigations by country, maybe by product type, but that's still to be worked out. But the idea would be that the 301 proceeding at USTR will implement additional tariffs that will take the place of the 122 tariffs once they run out. And Ambassador Greer talked about how that will be done on an expedited basis. The 301 requires, notice and comment. The last sets of 301 proceedings, there's been hearings. So I would imagine there'll probably be at least an attempt to set up some kind of hearing process, and then relief is published. So it'll move as quickly as they can, I'm assuming, but it looks like the 301 is going to fill the gap when the 122 runs out. So that's really the state of play today. And we'll see where this goes from here. Obviously, the big question for everyone is, well, okay, what about refunds? And it's the Supreme Court did not decide, the majority did not decide whether or how refunds should be given. They kicked that back down to the CIT to figure out. Years ago, there was a harbor maintenance tax that was imposed by customs, a harbor maintenance fee. which was ultimately struck down by the courts, which was actually, the fee was collected on every import that came into the United States across the board. There were no exemptions. So there was a similar process set up at Customs to refund that harbor maintenance fee that was collected. It's not clear whether Customs is going to set up a similar process. There's really been very little discussion by the administration about what or how they're going to do that. People have probably seen in the press, Costco had filed an appeal at the CIT. FedEx just filed a couple days ago. It seems as though, because there's no process in place yet, some companies, especially large ones, have started to file summons and complaint at the Court of International Trade as kind of a placeholder just in case, so that they have an opportunity to get these IEEPA tariffs refunded if it turns out that the administration doesn't actually set up a process. So that's kind of where we're at. You know, there's obviously a cottage industry now of flooding the CIT with summonses and complaints. And, you know, that's a decision folks will have to make about whether to do that. But because there's no process in place yet, we've seen a flood of filings at the CIT, really just as a placeholder for if nothing else, just in case. So that's the state of play. Happy to answer questions folks have.
I don't see any questions yet, Robert, but of course I have a couple. So section 122 is, as you said, limited, 6 months or 150 days. So I guess then if you look at it now, we move into the 301 investigations. That would be a more permanent fix, considering that, you know, who knows if they would get some other legislation through Congress. So are the 301 investigations just country specific, or are they country and product specific? How do those work?
Either or, it could be any of the above. So, for example, there's a 301 on shipbuilding. That applies to China specifically. Then there's a China 301 that's separate, that was done in the first Trump administration. But it could be country specific. You could have 100 301 investigations, one per country, or you could do one big one. I doubt they'll do one big one, or you could do sector specific 301 investigations. It's not clear. And when I say that 301s are more permanent, those tariffs are in place for a 4-year period, and then there's a review process that USTR will have to do to renew those tariffs. In the first 301 proceeding on the China 301 tariffs that were imposed in the first Trump administration, folks might remember the Biden administration had to conduct that review of those China tariffs, and they conducted the review. They found that they should continue, and they actually modified them and increased them for certain types of products. So it could be any of the above.
And in the China 301 investigation, or I don't know if you call it a rule or law, whatever it is, yeah, aluminum extrusions were specifically called out in there, if I remember correctly, but it was just the base codes, and it didn't. Maybe there was some others on other products, like I don't know if it was chips, or there was other things in there that were more specific on the products than kind of the base code. So could they? I guess they could do anything they want. They can really go deep into the tariff codes on some of these things.
Yeah, if you remember the first China 301 investigation, it started with, well, they had the notice and comment, and then they had tranche 1 or list 1, which was sort of the base codes that they were going to cover. and then the Chinese retaliated, so they expanded that to a second list. Then they expanded it to a third list, and then a fourth list. And depending on which list you were on, there were different tariff rates, and there's still different tariff rates depending on what list you're on. And there's some codes that were covered and some codes that weren't. And there was a process at USTR where you could file requests to have codes added or have codes taken off. And some got added, some got taken off. So I would imagine there's going to be a similar sort of process to either have things added or have things subtracted. Given how quickly that's going to have to move, getting something added or subtracted is probably unlikely, or more difficult at least, just given how quickly they want to move. Whereas in the China example I gave, that was a drawn out, probably 6 months, if I remember correctly, where you had list 1 and people were filing comments, and then list 2 and people were filing comments, and then 3 and 4. And then there was an exclusion process set up after that, which ran out and has not been renewed. So I suspect this will be a much more streamlined process than what happened previously.
All right. What is the opportunity? Because you said there's going to be, notice and comments and obviously a hearing. So when it comes down to these specific 301 investigations, for the AEC to make some very specific comments. Obviously, we're dealing in 7610 and windows and doors and all those, to make some more specific comments related to very specific products in our case.
Right. So I think there certainly will be a period to comment. That would be the normal process. We'll have to wait and see what that looks like. They're going to publish something and they're going to set up a comment period. It's probably going to be very short. For example, in the 232, I believe, the comment period that they set up for responding to requests to add things to the derivative list, I think it was 10 days. I think it's going to be something really short like that. Here, I think the comment for the AEC certainly would be that this kind of order of operation and the stacking that existed for the IEEPA tariffs and now for the 122 should be replaced. Right? If the 301 is ultimately going to replace what is in the 122, then the opportunity here is to say, for these particular products, maybe not all products, but at least these that you care about, you should allow whatever these 301 tariffs are going to be to stack on top of the existing 232 tariffs, because right now they don't. And so I think that's the real opportunity, and where there can be some real gains made for members, especially on products outside of, or what we call the derivative products, right? The things that contain aluminum extrusions, but more than just aluminum extrusions. It's those products right now that, if they're covered under the aluminum program, they're only covered under the aluminum program. So I think that's where the real opportunity would be, is to say, for these particular products, you ought to allow them to stack whatever that 301 tariff is.
One more question for me, and then we do have some questions coming in that I'll go through. So the 122, that is limited at 15%. That's the max, right? Correct? Okay.
Correct.
Does 301 have any kind of limiting?
Nope. No. And 301, I mean, they will use it to impose tariffs, don't get me wrong, but there is no limit to the amount that they could impose. It could go whatever number they think is appropriate.
Sorry, now I'm just thinking of another question. But so does a 301 act more like, let's say the current China orders, where you go, can you show that you could show the damage that is being done? Can you get that detailed in your comments? And
Yeah, you certainly could. Going back to how they structured the last China 301, they had actually already announced list 1, list 2, list 3, list 4. And they said everything on list 1 is going to get this rate, list 2 is going to get this rate, and 3 and 4. And then now comment on whether these things should be on this list or that list, or removed from a list, or moved from list this to the other to get a lower rate or a higher rate. I don't know how they're going to do it here. Like, setting up those kind of bands. Certainly, I think if you were commenting and saying, whatever you're planning on doing, it needs to be a significant, amount for these particular products because of the harm that's been taking place. I think that's certainly fair game.
Okay. All right. So
before you jump in, Jason, just one particular other thing I forgot to mention about 122. So some people might have seen, there's been some commentary, especially by the importers, about whether the president has even the authority to impose tariffs under the 122. Because it's a balance of payment provision, the administration and EEO tried to address because we've been running trade deficits, this creates a balance of payments issue. There's some commentary that, well, it kind of doesn't, that the balance of payments provision, when it was enacted by Congress right about when the US was leaving the gold standard. And the real concern was when we leave the gold standard that we might create a balance of payments problem, and that we had to have some mechanism to offset that. And since we've been off the gold standard for a very long time now, we don't really have balance of payments issues as a result. Running consistent trade deficits doesn't really satisfy the statute. Having said that, because these are only in place for 150 days, filing an appeal and getting a resolution before these things run out is probably unlikely. But if you're wanting to get refunds for the 10% or the 15% that you wind up paying in that 150 days, you're going to have to appeal it. So there's probably, I'm sure, going to be more litigation on the president's authority here in the 122. But whether that has any practical effect in the short term, I doubt it, given the timing.
All right. Okay. Let's go through some of these questions here. We get several. First one is, what is the deal with the aluminum imports remaining at 50%? They were part of the Supreme Court's ruling. I guess the answer to that is no, right? Because that's 50% is 232. The 232 was not part of the ruling.
Exactly.
Next question, again, revolving around 232. Have you heard anything regarding a shift on 232 aluminum tariffs moving to full import value versus aluminum content value as part of the simplifying the process that Greer mentioned last week?
Yes, we're hopeful that we're close to a fix. Exactly when that's going to take place, we're not sure. We were hopeful it was going to happen sooner rather than later. The Supreme Court decision probably delayed that because now the administration has to get the 129 or 122 up and running, start these 301s, and there's only so many bodies to go around. So it might delay that fix a little bit longer.
So on the 301, what is the time frames? Obviously, with the countervailing anti-dumping orders, is what you got 7-year review. Every year you do an annual review. Is that follow a similar pattern?
Sort of. So AD/CVD, it's a 5-year window, right? And then you got to do a sunset review. On a 301, it's a 4-year window. And then you have to do a review to determine whether they should remain in place or do something else. So it'll be similar to that regard. There's no annual review to adjust the rates in a 301 context.
All right. Next question. Can you discuss how the 122 and 232 play into extrusion imports? My understanding is that the 232 currently applies only to the aluminum content, not the total value add, whereas the 122 would apply to the value added portion of the cost. So while 122 and 232s don't stack, they would both apply to different cost elements of extrusion imports. Is that a correct understanding?
It was certainly correct when in the IEEPA context, and I believe it's still correct here because they follow the same structure. Obviously, if and when we get a fix for the valuation problem, that may change, but until we see that fix, we won't know.
Next question. Do you expect the 301s to eventually be stacking on top of the 232?
So that was what I was talking about earlier. I don't know the answer to that. I certainly think, again, to your question earlier, Jason, about what should the AEC be requesting, that's exactly what you should be requesting. That at least for your products or the products you care about, they should stack. Whether that happens or not, we don't know, but if you don't ask, you don't get it.
All right. Oh, here's another question about stacking tariffs. Can you repeat that last part about stacking tariffs? My connection cut, so maybe you can go through the stacking again.
Sure. So if folks remember, back when the IEEPA tariffs were issued, they also issued a memo about basically the order of operations, how what tariffs were going to be collected. And they explicitly said that anything that was covered by any 232, so the auto 232, the truck 232, the aluminum 232, the steel 232, anything that was covered there was not also covered by the IEEPA tariffs. In other words, if there was an IEEPA tariff of 10% and the aluminum tariff of 50, and the product was 100% aluminum, you only collected the 50%, you didn't collect 60. But for products where there was a mixture of aluminum content and non-aluminum content, then you collected, the 50% on the aluminum content and then the 10% on everything else. That seems to be still the case with the 122s. When the 301s ultimately replace whatever the 122 is, it's not clear whether those will continue to follow that same principle, or, I think the opportunity there is to ask that you don't follow the same principle, that you allow them to stack on top of each other at full value. When the administration fixes the valuation problem currently, it's also possible that this 50% on the aluminum content and 10% on everything else will go away, and it'll be some percentage on the full value, period.
Okay. Last question. If the president chooses to adjust the 122 to 15%, does the time period of 150 days start over?
I don't know. My initial thought was, when they announced the 10%, that was why they did it, was to buy themselves another 150 days to say, first program's at 10%, 150 days runs out, then I do 15, and now I get a new 150 days. The way they're talking about moving from 10 to 15 doesn't seem to be that's what they're thinking. It seems like they want to move to 15 for some, but not all. in that scenario, you probably wind up in the same 150 days. I don't think that buys you another 150 days.
Well, then, yeah, I guess what I would say, if that was really what they're thinking, that they get another 150 days, then don't move it to 15, move it to 10, or from 10 to 11 to 12.
Yeah, right. Yeah, you start at 10 and then, you know, move up from there. But if you're mixing and matching, some people get 15 and some get 10, then it seems like it's just one program. And so you're probably stuck at the 150 days.
Okay. That is all the questions I've seen.
All right.
Well, I appreciate it, Robert. Again, for everybody on the line here, we will put this out. Yes, behind the we'll put it behind the paywall so only members can get it. But again, thank you very much for your time today, Robert.
Yep.
Keep up the good work. Keep up the fight.
All right. Well, thanks everybody. I appreciate it.
All right. Bye.